Maya got the offer at 5:43 on a Thursday. She screamed, ordered tacos, and almost typed her resignation. Almost. Then the recruiter added one sentence. Of course, it's contingent on background check clearance. That sentence is where offers go to die. The offer is not real when you sign it. It is real when every contingency clears and someone says, in writing, you're good. Most people treat the background check like paperwork. Maya did too. New role, better title, bigger paycheck. She had already mentally moved. PBSA says its survey of 1,590 HR professionals found nearly all use background screening, usually after an interview or offer. So here's Rule 1. Do not resign, relocate, or buy the celebration flight until contingencies are cleared in writing. A background check is a second hiring funnel. It starts after you relax. That timing is the trap. The FTC says employers generally need your written permission before getting a consumer report for employment purposes. Before you authorize anything, ask, what items are disqualifying for this role, and when exactly do you run the check? Maya had never asked that. She assumed they were checking felonies. They were checking employment dates, addresses, credit, and vendor records. In 2024, the CFPB said third-party background dossiers and algorithmic worker scores used for employment decisions often trigger FCRA obligations. Translation: this is not just a criminal search anymore. It can be a career dossier built by companies you've never heard of. Cheat code: pre-audit yourself before the employer does. Give yourself 7 days before serious applications for sensitive roles. Consider pulling your own credit report if the role touches finance, security, or regulated work. You want surprises before they do. Check court records in counties where you've lived. Wrong matches happen when names, birth dates, or old addresses get mashed together. Verify your employment dates, not vibes. Exact month, title, employer entity, and whether payroll listed you under a parent company. If your job needs a license, check the license status yourself. Expired, suspended, or mismatched records can kill the offer fast. Before an employer rejects you based on a report, the FTC says they must send a notice, the report, and FCRA writes. Beat! That notice is not a rejection yet. It is your last clean shot to stop a bad report from becoming final. Maya's notice said one employer couldn't verify her last job. The report made it look like she invented 18 months. Her first move took 90 seconds. I dispute the accuracy and completeness of this report. Please keep the decision open during investigation. Notice the wording. She did not beg. She disputed. She asked them to keep the decision open. That's the whole ballgame. Send proof, not paragraphs. Pay stubs, W-2s, offer letters, court dispositions, sealing orders, license verification, clean documents beat emotional explanations. After final adverse action, the FTC says employers must identify the reporting company and explain dispute rights, including a free report within 60 days. But don't wait for final adverse action. Once final happens, you're playing defense after the scoreboard changed. The EEOC says employers must apply background check standards equally and avoid exclusions that aren't job-related and consistent with business necessity. If the issue is real but old, ask why it matters for this job. Not every record belongs in every decision. Use this line: can you explain how this specific item is job-related for this specific role? Stay calm. Make them connect it. False records are not rare magic. They're database problems. Common name, old address. Court clerks, vendor gaps, human sloppiness. Pre-audit your identity trail. List every name variation, prior address, and employer entity. Background vendors search what you give them. If you have a common name, include the middle initial consistently. Tiny identity details can separate you from someone else's problem. The CFPB says employment dossiers obtained from third parties, like scores or background files, can be consumer reports under FCRA. When you receive a notice, ask for the background company name immediately if it is not obvious. You dispute with them too. Send one dispute to the employer contact and one to the reporting agency. Same facts, same attachments, same attachments. Do not assume the recruiter will fix the vendor report. Recruiters fill roles. You fix your record. Keep receipts. Screenshot submission confirmations. Save emails. Track calls. If the decision closes, your paper trail becomes leverage. Howard's voice. Timing matters because employers move fast after pre-adverse notices. You need a response in hours, not a week. Your 24-hour goal is simple. Freeze the decision. State the dispute. Send initial proof and promise more documentation. Build a background check packet now. Identity list, employment proof, education proof, licenses, court documents, and a short dispute template. Credit data is sneaky. You may never discuss it in interviews, then it appears because the role handles money or risk. Consider asking early if credit history is part of the screen. The question is professional, not suspicious. The FTC frames employment background reports as consumer reports when employers use outside companies to gather background information for hiring decisions. Social media can also get checked. Don't perform a fake personality scrub. Remove public chaos that distracts from your candidacy. Today, review public profiles. Archive angry posts. Tighten privacy settings. Make sure your name search does not become the recruiter sideshow. Algorithmic worker scores are the new weird layer. Attendance patterns, platform ratings, productivity signals, and risk scores can follow people. The CFPB circular says FCRA can apply when algorithmic scores are bought from third parties for hiring, promotion, reassignment, or retention. Ask this if the role is platform-heavy. Do any third-party tools or worker scores factor into employment decisions? If a mysterious score hurts you, don't argue with the mystery. Ask what company produced it, then dispute the underlying data. Maya's report was wrong because her previous company used a payroll subsidiary. The vendor searched the brand name only. She sent pay stubs, a W-2, her offer letter, and a manager contact. 4 proofs. No speech. No panic. The employer paused the decision. The vendor corrected the report. The offer survived because Maya moved before the final notice. The FTC says advance notice gives people the opportunity to review the report and tell employers whether it is correct. Firmly, do not apologize for an inaccurate report. You did not create the error. Your job is to correct the record fast. Use this exact sentence. The report is inaccurate. Attached are documents showing the correct information. Please confirm review before any final decision. Now, if the record is real, the move changes. You prepare context before they ask, especially for regulated or trust-heavy roles. Don't hide facts if you're lawfully asked, but don't overshare either. Brief context, accountability, time passed, relevance, and proof of stability. The EEOC guidance says criminal history exclusions should be job-related and consistent with business necessity, not lazy blanket filters. Prepare a 1-page context note: what happened, what changed, why it won't affect this job, and proof supporting that claim. If expungement, sealing, or legal rights are involved, consider consulting an employment attorney. Internet threads are not strategy. Exhale, Maya started 3 weeks later, same offer, same salary, different mindset. She never treated contingencies like decoration again. This is the before-after. Before, she celebrated the offer. After, she celebrated the clearance. Your checklist? Ask screening scope, delay resignation, pre-audit records, save proof, dispute fast, and demand the report when something looks wrong. If this episode saves one offer, tap like and subscribe. Keep it simple. I want you protected before the ambush. Every offer email should trigger one reply. Please confirm all contingencies and the exact point when the offer is fully cleared. Say it like an adult, not a defendant. Contingency clarity is normal. People with options ask clean questions. Red flag: you get a vague problem but no report. That is not enough. You cannot dispute a ghost. Respond: please send the report, the specific item at issue, and the FCRA rights summary so I can respond accurately. FTC guidance says final adverse action notices must also explain the right to dispute accuracy and request another free report within 60 days. If you believe the rescission was unlawful or discriminatory, consider speaking with an employment lawyer or appropriate agency. Move with documents. Save the offer, disclosure, authorization, notice, report, dispute, attachments, and final decision. If this escalates, memory is useless. The cheat code is not fear. It's sequence: audit first, authorize smart, react fast, celebrate last. Recap: the offer isn't real until clearance. Pre-audit your record. Know your FCRA moves. Send proof. Keep the decision open. Because the worst time to learn background check rules is after you already told everyone you got the job.